Every time you buy a refrigerator, a television, or even a simple smartphone, you likely glance at a folded piece of paper in the box and trust that if the machine stops working, you are legally protected. You assume that a promise on the box means the manufacturer is on the hook to fix their own mistakes. But until 1975, a standardized, federally regulated consumer product warranty did not exist in the United States. That folded piece of paper you rely on today was historically used as a legal trap. What happened when expensive household machines just broke? And how did consumers survive in a market where corporate promises were entirely unregulated? This is not just a story about broken appliances and frustrated shoppers. It is a story about a massive shift in economic power, detailing how industrial giants built a legal fortress to protect their profits, and what it took to finally breach those walls. To understand how heavily the deck was stacked against the buyer, we have to look back to the era before mass production. For centuries, the rule of commerce was governed by a simple Latin phrase, caveat emptor, or let the buyer beware. If you bought a wagon wheel or a wooden chair in the 19th century, you usually bought it directly from the craftsman who made it. You could inspect the wood, test the weight, and judge the quality with your own eyes. If the wheel splintered the next day, you knew exactly who to blame. You walked it right back down the street to the blacksmith or carpenter. The legal accountability was direct and personal. But the turn of the 20th century brought a radical transformation to American life, introducing complex, mass-produced machines into the home. Suddenly, consumers were spending vast sums of money on automobiles, mechanical washing machines, and electric radios. These were products of unprecedented complexity, assembled in massive factories located hundreds of miles away. You could no longer inspect a product and intuitively understand if it was built well. The inner workings of a combustion engine or a vacuum tube radio were mysteries to the average buyer. More importantly, you were no longer buying from the person who built the machine. You were buying from a local dealer, a middleman who had no part in the manufacturing process. This created a massive legal loophole for the industrial giants of the era. They relied on a strict legal doctrine known as privity of contract. Privity of contract meant that legal obligations only existed between the two parties who directly exchanged money. Because you handed your cash to the local car dealer, your contract was only with that dealer. The massive corporation in Detroit that actually built the defective car owed you absolutely nothing. If the engine block cracked on your drive home, the manufacturer was legally shielded from your anger. Courts consistently ruled that without a direct contract, the consumer had no right to sue the manufacturer for a poorly made product. The local dealer, meanwhile, rarely had the resources to replace a shattered engine or a fundamentally flawed appliance. The consumer was left holding a completely useless, highly expensive piece of metal. As public frustration mounted, manufacturers realized that completely ignoring broken products was damaging their ability to sell new ones. To soothe anxious buyers, companies began including ornate certificates with their products, proudly labeling them as express warranties. To the untrained eye, these documents look like ironclad guarantees of quality. They featured official-looking seals, complex legal phrasing, and promises to replace defective parts. But these early documents were not designed to protect the consumer. They were carefully engineered legal shields, drafted by corporate attorneys to protect the manufacturer from a far more dangerous legal threat. That threat was the concept of an implied warranty. Under common law, there was a growing legal understanding that if a company sold a product, there was an unspoken, implied promise that the product was actually fit for its intended purpose. If you bought a washing machine, it was implied that the machine would actually wash clothes without tearing itself apart. Manufacturers were terrified of being held liable for these broad, implied promises, so they used their new, written, express warranties as a weapon. By offering a very specific, highly restricted written warranty, companies could legally insert a clause that explicitly canceled out all implied warranties. They would promise to replace a specific defective gear for 30 days, but only if you paid for the shipping and the labor. Buried in the fine print at the bottom of the certificate was the true purpose of the document. It stated that this limited promise was given in lieu of all other warranties, expressed or implied. When the consumer accepted the written warranty, they were unknowingly signing away their fundamental right to demand a product that simply worked as advertised. The very piece of paper they thought was their protection was actually their surrender. If a newly purchased car's steering column snapped and caused a catastrophic accident, the manufacturer would simply point to the warranty. They would generously offer to replace the 50-cent broken bolt, while disclaiming any responsibility for the thousands of dollars in resulting damage or injury. This system of deceptive, manufacturer-written warranties dominated the American economy for decades. Corporations held all the cards, dictating the terms of their own liability without any government oversight. As the post-war economic boom of the 1950s flooded American homes with increasingly complicated and expensive appliances, the tension reached a breaking point. Millions of consumers were sinking their savings into televisions, refrigerators, and new cars, only to find themselves trapped by fine print when these mechanical marvels inevitably failed. The legal architecture of the consumer market was fundamentally broken. It would take a rising wave of consumer advocacy, a series of bitter legal battles, and a complete reimagining of commercial law to finally force a change. The battle lines were being drawn for a conflict that would eventually reach the halls of Congress, culminating in a sweeping federal intervention. But before the government stepped in, the everyday buyer would have to endure a gauntlet of broken promises and deliberate corporate obfuscation. The struggle to redefine exactly what a corporation owed its customers was about to begin in earnest. And it would start with a few brave individuals who decided that a piece of paper filled with legal traps was no longer an acceptable substitute for a working product. The first major crack in the absolute power of the corporate warranty did not come from a powerful politician or a federal agency. It came from a man named Klaus Henningsen, a routine car purchase, and a devastating accident that exposed the absurdity of the entire legal framework. In May of 1955, Henningsen went to Bloomfield Motors in New Jersey to buy a new Plymouth sedan for his wife Helen. When he finalized the purchase, the dealer placed a standard contract in front of him. Like millions of Americans before him, Henningsen signed it without reading the microscopic fine print crammed onto the back of the page. That fine print was the standard uniform warranty drafted by the Automobile Manufacturers Association. It stated that the manufacturer, Chrysler, would replace defective parts within 90 days or 4,000 miles. In the very next sentence, it explicitly stated that this promise was strictly in lieu of all other warranties, expressed or implied, and all other obligations or liabilities. 10 days later, Helen Henningsen was driving the Plymouth at 20 miles per hour when she heard a loud crack under the hood. The steering wheel spun freely in her hands, completely disconnected from the axle. The car veered violently to the right, crashing into a brick wall. The Plymouth was destroyed, and Helen suffered serious injuries. When the Henningsens sought compensation from Chrysler for the totaled vehicle and the medical bills, the corporation invoked a uniform warranty. Chrysler's legal department pointed to the fine print Klaus had signed. They argued that their only legal obligation under the contract was to replace the broken steering mechanism. They offered to hand the Henningsens a new 50-cent metal joint while refusing to pay a single cent for the destroyed car or the hospital bills. For decades, courts had accepted this exact defense, dismissing the consumer and protecting the manufacturer. But the Henningsens refused to accept the 50-cent settlement, and they sued Chrysler, pushing the case all the way to the New Jersey Supreme Court in 1960. In a landmark decision that sent shockwaves through corporate America, the court ruled entirely in favor of the Henningsens. Justice John J. Francis delivered a scathing opinion that tore apart the illusion of the express warranty. He noted that the uniform automobile warranty was used by the big three automakers, who controlled over 93% of the market. The consumer had absolutely no bargaining power to change the terms. It was a take-it-or-leave-it proposition, dictated by a massive oligopoly. The court declared that burying a disclaimer of basic safety and liability in fine print was completely against public policy. They ruled that when a manufacturer puts a car into the stream of commerce and promotes it to the public, an implied warranty that it is reasonably suitable for use automatically accompanies it. The Henningsen ruling effectively destroyed the privity of contract defense that had shielded manufacturers for half a century. It established that corporations could not simply write their way out of basic legal responsibility through deceptive contracts. While this was a massive legal victory, it did not immediately solve the everyday problems of the American consumer. The Henningsen case proved you could win if you sustained catastrophic injuries and could afford to fight a multi-year battle in the state Supreme Court. But what if you bought a toaster that simply refused to heat, or a television with a faulty picture tube? You could not take a washing machine manufacturer to the Supreme Court over a $50 repair bill. Through the 1960s, a new movement began to gather momentum, driven by a growing class of consumer advocates who realized that case-by-case lawsuits were insufficient. In 1962, President John F. Kennedy delivered a special message to Congress, formally outlining a consumer bill of rights. He explicitly named the right to safety and the right to be informed, signaling a shift in how the federal government viewed the balance of power in the marketplace. However, soaring rhetoric did not immediately change the behavior of major manufacturers. Automakers, in particular, realized they could use warranties not as legal shields, but as aggressive marketing tools. Throughout the 1960s, companies began heavily advertising extended warranties, promising 5 years or 50,000 miles of coverage. These bold promises sold millions of cars, but the service infrastructure backing them up was entirely hollow. When consumers actually tried to use these heavily marketed warranties, they ran into a wall of systemic, engineered resistance at the dealership level. To understand this friction, you have to look at the mechanical, financial relationship between the manufacturer and the local dealer. When a mechanic performed a repair for a customer paying out of pocket, the dealer charged their standard, profitable retail rate for parts and labor. But when a mechanic performed a warranty repair, the manufacturer reimbursed the dealer at a severely reduced wholesale rate. This created a massive financial disincentive for dealerships to honor the very warranties their parent companies were aggressively advertising on television. Dealers instructed their mechanics to prioritize cash-paying customers over warranty customers. If you brought your car in with a rattling transmission under warranty, you were routinely pushed to the back of the line, forced to wait weeks for authorized parts to arrive. Mechanics, paid on a flat-rate system, rushed through warranty work because they were being compensated at a lower rate, leading to shoddy repairs that frequently failed again. The Federal Trade Commission finally took notice of this escalating crisis, launching a massive investigation into the automobile warranty system. In 1968, the FTC released a devastating report that laid bare the entire deceptive ecosystem. The commission found that performance rarely matched the promise, documenting thousands of cases where consumers were stranded without vehicles, battling indifferent dealers and hostile manufacturers. The report proved that the free market had failed to regulate itself, and that state courts were moving too slowly to protect the average buyer. The evidence was undeniable. The entire architecture of consumer guarantees was fundamentally deceptive, designed to generate sales while strictly limiting corporate financial exposure. Public outrage reached a boiling point, catching the attention of lawmakers in Washington who realized that piecemeal state laws were no longer enough. The stage was finally set for federal intervention, led by 2 senators who decided it was time to forcefully rewrite the rules of American commerce. The momentum generated by the Federal Trade Commission report could no longer be ignored by lawmakers in Washington. The responsibility of transforming public outrage into binding federal law fell primarily to Senator Warren Magnuson of Washington and Representative John E. Moss of California. Magnuson was a veteran legislator who had already spent years fighting for consumer safety standards. Moss was a fierce advocate for transparency who had previously authored the Freedom of Information Act. Together, they recognized that simply forcing companies to offer a warranty would not solve the crisis. The core problem was the deceptive language used to trap the consumer. Their goal was not to mandate that every product must have a guarantee, which would have disrupted the entire manufacturing economy. Instead, they wanted to force radical transparency upon the existing system. If a company chose to offer a written promise, that promise had to be clear, enforceable, and stripped of legal camouflage. This philosophy became the foundation of the Magnuson-Moss Warranty Act. Drafting the legislation required overcoming massive lobbying efforts from manufacturing associations who warned of economic ruin. Industry lawyers argued that federal oversight would force them to eliminate consumer protections entirely. But the lawmakers held their ground, pushing the bill through the legislative gauntlet. On January 4, 1975, President Gerald Ford signed the Magnuson-Moss Warranty Act into law. This moment marked the introduction of the standardized, federally regulated consumer product warranty we rely on today. To understand how profoundly this law changed everyday commerce, we must look at the specific mechanical rules it imposed on manufacturers. First, the law attacked the deceptive practice of burying disclaimers in fine print. It mandated that any written warranty for a consumer product costing more than $15 must be fully disclosed in simple, easily understood language. You no longer needed a law degree to understand what was covered and what was excluded. Second, the act established a strict federal standard for how warranties were labeled. Before 1975, a company could stamp the word guarantee in bold letters across a box, even if the actual document offered almost no protection. The new law forced manufacturers to explicitly designate their promises as either a full warranty or a limited warranty. This is a mechanical distinction that still dictates how you buy products today. If a manufacturer chose to offer a full warranty, they had to meet rigorous federal standards. Under a full warranty, the company was legally obligated to repair or replace the defective product within a reasonable time and entirely free of charge. They could not force the consumer to pay for shipping, labor, or replacement parts. Crucially, if the product could not be repaired after a reasonable number of attempts, the consumer was entitled to a full refund or a complete replacement. This became known as the anti-lemon provision. Furthermore, offering a full warranty meant the manufacturer was strictly prohibited from limiting the duration of any implied warranties. The unspoken promise that a product was fit for its basic purpose could no longer be signed away. However, the law also provided an alternative for manufacturers who could not meet these strict requirements. They could offer a limited warranty, but they were legally forced to label it exactly that way, right at the top of the document. A limited warranty allowed the company to specify exactly what parts were covered and for how long. But the word limited served as a giant, federally mandated warning sign to the buyer. The legislation also outlawed a highly lucrative, coercive tactic known as tie-in sales. Previously, a manufacturer could state that your coverage was completely void unless you exclusively used their branded repair parts or their authorized service mechanics. If you put a generic oil filter in your car, the automaker would cancel your entire engine guarantee. The Magnuson-Moss Act explicitly banned this practice. A company could no longer force you to buy their overpriced accessories just to keep your warranty valid, unless they provided those parts for free. Finally, the law gave the consumer a realistic way to fight back when a company broke its promise. It included a provision allowing successful plaintiffs to recover their attorney fees and court costs. You no longer needed to be wealthy to take a multinational corporation to court over a broken refrigerator. If the manufacturer refused to honor the warranty, A local lawyer could take the case, knowing the corporation would foot the legal bill when they lost. This specific mechanism shifted the financial risk of litigation from the buyer back to the manufacturer. The Magnuson-Moss Warranty Act fundamentally rewired the power dynamics of the American marketplace. The era of the deceptive, manufacturer-dictated legal shield was officially over, replaced by a system where words actually had binding, federally enforced meaning. The immediate consequence of the Magnuson-Moss Warranty Act was a massive recalibration of corporate behavior. Manufacturers suddenly realized that the promises they printed on their boxes were now enforceable federal obligations. The initial reaction from the industrial sector was predictable panic. Many companies immediately downgraded their sweeping, vague guarantees to strictly labeled limited warranties, terrified of the new liability standards. But this was exactly what the law intended, forcing the market to reflect reality rather than marketing fantasy. The consumer was finally armed with the legal clarity needed to make informed purchasing decisions. However, the creation of a regulated warranty system did not eliminate friction between buyers and sellers. It merely shifted the battleground. The law explicitly encouraged companies to establish informal dispute resolution mechanisms to handle the inevitable flood of complaints. This led to the creation of third-party arbitration boards, heavily funded by the auto industry, designed to settle disputes before they ever reached a courtroom. Today, when you buy a new car and sign a stack of paperwork, you are often agreeing to mandatory binding arbitration, a direct evolutionary descendant of those early resolution boards. While the Magnuson-Moss Act gave you the right to sue, modern corporate contracts frequently require you to waive that right in favor of private arbitration. The tension between public consumer protection and private corporate risk management remains a defining feature of the modern economy. The manufacturers lost their absolute power to dictate terms in the fine print, but they adapted by building new, highly complex legal architectures to manage their exposure. The local dealers lost the ability to openly discriminate against warranty repairs, as manufacturers were forced to standardize reimbursement rates to avoid federal scrutiny. The ultimate winner was the American consumer, who gained a baseline level of transparency that simply did not exist prior to 1975. The piece of paper in the box transformed from a deceptive legal trap into a binding contract that, while imperfect, provides a fundamental layer of economic security. Yet new challenges constantly emerge as products evolve from mechanical machines into complex digital ecosystems. When a modern tractor or a smartphone fails, the line between a hardware defect and a software failure is often blurred, creating new legal loopholes that the architects of the 1975 law could never have anticipated. The fight over the right to repair digital devices is the modern continuation of the battle that began with a broken steering wheel in a New Jersey Plymouth. And this is where the old question lands squarely in your own life today. When you exchange your money for a complex machine, who should ultimately hold the power when that machine fails? The corporation that designed it and controls the fine print, or you, the person who paid for it and lives with the consequences? It is a tension worth taking a side on, because the answer shapes every purchase you make. The Magnuson-Moss Warranty Act established that the answer cannot simply be caveat emptor. It proved that a complex mass production economy requires basic, enforceable rules of fairness to function effectively. The standardized warranties you rely on today are not generous gifts from benevolent corporations. They are the result of decades of legal warfare, public outrage, and forceful government intervention. They stand as a testament to the idea that the rules of commerce are not fixed laws of nature, but human-made systems that can be challenged and rewritten. If you find value in understanding the hidden histories behind the systems that govern your daily life, subscribe to the channel. We will continue to investigate the origins of the institutional architecture that shapes our modern world.